Afternoon, and welcome to another Understanding Town Government show. Our guest today is Peter Barrett, Judge of Probate for Guilford and Madison. Peter, what is it that you do as a Judge of Probate?
First of all, good evening, Dennis. Thank you for having me here. As Judge of Probate, my job is to make sure that the probate laws of the state of Connecticut are followed and are properly applied in our district. And our district is Madison, Guilford. And to do that, we have a courthouse with full-time clerks and a hearing room, and we have probate court archives where our files are stored.
And it's just Guilford and Madison, no other?
Correct.
And was there a time when Guilford had its own probate court?
Yes, as a matter of fact, both Guilford and Madison did have their own probate courts. In 2010, there was a consolidation. There used to be 117 probate courts in the state of Connecticut, and each one ran as its own little court system and its own little business. As you might imagine, some of the courts flourished, and some of them had a lot of financial issues, especially in the cities. And it wasn't the most economic way to run the probate system. And so after much discussion and debate, there was legislation passed to change the system and to consolidate the courts from 117 to 54 courts. And as a result of that, I think we were fortunate that our one-town court became a two-town court, Madison and Guilford. There's other districts that consolidated 9 different towns together, and you can imagine that the mechanics of doing that were probably pretty difficult. But with Madison and Guilford, we have very similar demographics. Obviously, we're right next door to each other, and it seems to have worked out very well.
And where's the court located?
The court is located on the second floor of the old Memorial Town Hall in Madison. Beautiful old building, right on the right on the Madison Green. 8 Meeting House Lane actually is the address. They used to have the Madison Court in that building as well, though in a much smaller space. And so it's a little tight, but it serves our purposes very well.
What do you mean the Madison Court?
When Madison had its own probate court,
I see.
At least for a period of time, they had used that same building. I remember going there as a private attorney. But it was a smaller space and larger. We take up more room, and it runs very well.
Now, probate courts administer proper distribution of the assets of one who has died. Is there more to this than what I'm saying?
Well, yeah, you're talking about, that's one of the big things we do is we administer decedent's estates, and that's what we call that, a decedent's estate. Somebody's passed away, owning assets, and there has to be a manner by which those assets are passed on. So there's 2 basic types of estates. There's what's called a testate estate, and those are estates in which there's a will. The deceased person has left a will. And then there's intestate estates where somebody has died without a will. And so obviously we administer both of those. They're very different in some respects, but the ultimate object is the same, which is to make sure there's an orderly transfer of assets from a deceased owner to new owners.
And so you decide the validity of the will and enforce the provisions of the will.
Yeah, so we'll talk about that one first. So if there's a will, then there's certain things that have to be complied with to make that valid. We have to take a look at that, make sure that it's been duly executed in front of 2 witnesses, that its terms are specific enough so that we can tell what the decedent intended. If the will is challenged, as sometimes it is, it might be challenged on the basis that somebody unduly influenced this person to do the will, or that perhaps the person lacked mental capacity to execute a will. And so those would be the type of issues we'd have to resolve as a threshold before we admit that will. However, assuming that it's admitted either without objection or an objection has been made and we've upheld the will, once the will is admitted, we follow it. And if it names somebody specific to be the executor, the person who's going to make sure the will is followed, then we name that executor. If it says that assets are to go to a certain person, even if that's not what we would expect to see, we nevertheless make sure the will is followed, because that's an expression of what that deceased person wanted to be done with their assets. So that's your decedent's estate. And then intestate, a little different. An intestate estate, there's no will, and so the court will have to determine who's the right person to kind of shepherd this estate through the probate process. And usually a family member steps up and does that, or volunteers to do that, and sometimes not, and we'll have to appoint an independent person. But again, the result is the same, is to get the assets transferred. The difference, of course, being that the decedent hasn't told us who he or she wants the assets to be transferred to. And so we have a whole set of laws that fill in that blank. And basically it's going to go to next of kin. It'll go to the spouse and next of kin in a very orderly fashion. And so we'll determine who the next of kin is, the different levels of their relationship. And based upon that, that'll determine who gets the assets. And the only other thing I'll add there is that person, whoever that administrator of the estate is, will generally require a bond to make sure that they faithfully fulfill their duties as an administrator.
I'm curious about these dishonest practices. What have you run into?
Well, you know, we have to keep our guard up. I mean, anybody who is appointed as a fiduciary, we use that term broadly for anybody who's got a position of trust, they are nevertheless an agent of the probate court. So when we appoint somebody, it's our obligation to monitor and supervise what they do. So yes, sometimes you can find people trying to take advantage where they shouldn't, and it might be, I haven't run into a lot of that, but some, and sometimes it might be somebody's trying to make a reimbursement claim that they shouldn't, or they're trying to direct assets in a direction where they shouldn't go, or, you know, those are some examples. Or they're misusing some of the funds for their own personal profit. So the best way to address that is to make sure that there's periodic reporting, okay, and that we keep the process moving, and we carefully review whatever papers are filed by that fiduciary, especially their accountings.
A fiduciary is?
A fiduciary is that broad term, anybody who's got a position of trust.
I see.
In the probate court. So it includes the executor named in a will. It includes an administrator of an intestate estate. It includes conservators and people acting under a power of attorney. Okay?
Okay, I see.
And so they're in the position of trust where they might have an opportunity to take advantage. And believe me, the majority act very fairly and in an appropriate way. So we don't run into it too often, but it is our job to make sure it doesn't happen.
Now, is there anything, before we move on to other aspects of your job, is there anything more that you would like to say about this, what we've been discussing so far, that I've missed?
Yeah, well, I think there's a whole kind of second half to what we do. So most people think that what we do in the probate court are these decedents' estates,
right.
And a very important part of what we do. But there's a whole nother area of law that we operate in, which most people will kind of consider a social services type.
Well, I understand that one of the things that is guardianship of children.
Yeah, yeah.
Tell me about that.
All right. We sometimes children are in a difficult situation for a variety of reasons. There might be drug or alcohol abuse in the family, domestic violence. There might be some aspects of mental illness in the family, and it's putting a child at risk. And so the probate courts are called upon to hear those cases and protect those children. And there's two principal ways we do that, and that is to assign custody when necessary. Usually and often it's under an emergency situation. There's something extreme happening, and maybe a grandparent will step in and say, look, I want to take temporary custody of of my grandson or granddaughter because mom and dad aren't doing their job, and we hear that case and we decide that. And that may lead to a removal of the parents as guardians, and appointment of somebody else to be a guardian for that child. And then in extreme cases, sometimes a parent is really just abandoned or even hurt a child, and we're called upon to, or that's the allegation, and we're called upon to determine if that parent's parental rights should be terminated altogether. So that's a very grave responsibility, an important function of the probate courts. We see some of that in Madison and Guilford. As you might imagine, in some of the cities, in large population areas, it's more significant, but we do have our issues in Madison and Guilford too.
Just as I understand the discussion I had with somebody else a while ago, you can't really will your children to anybody. You can't say, you can't in a will specify, I want Aunt Mary to take them.
Well, actually, you can't do that over another parent.
Right.
If there's two parents and one of them passes away, the other parent is the natural continuing guardian of that child. But if both parents have passed away and the child's still under the age of 18, yes, in a will you can name who you would want the guardians to be. Now, there are situations in which a court can say, wait a minute, based upon the circumstances, I'm not going to make that appointment. But generally speaking, the courts will look at the will, and if there is a guardian named, who the parents want to name, they'll seriously consider appointing that person or persons.
Okay.
It's an expression by the testator of who, by the decedent of who they wanted, who they would trust while they were alive.
It's very important for our audience to know about that.
Yes.
And there's a guardianship of adults as well.
Yes, there is a whole set of laws and procedures for the appointment of a guardian for an intellectually disabled person. So these are people who have an intellectual disability, generally born with that, okay? And so they're identified usually in school, and as they get older, they're well cared for by their parents, and they may have special programs in school for them. But when they reach 18, absent some further legal process, they are assumed to be full adults, capable of running their own lives and making their own decisions. So there is a process. Obviously not every child is going to be able to do that. There is a process by which we can appoint guardians for the intellectually disabled. And so that's somebody who is unable to run a checkbook and pay their bills, or comprehend how to use money, for instance, or make medical decisions. They'll have a guardian that can do that for them and help them. And one thing I should point out here, that level of guardianship is not necessarily an all or nothing proposition. Okay, so that if somebody's intellectually disabled and they have only a certain need, then what we do is we appoint a limited guardian and say, well, this person needs help with their medical decision making, and so we're going to appoint a guardian for that purpose, but maybe not to determine where they live. Maybe this person can still decide who they want to live with on their own. So there would be a limited guardianship as opposed to, in some situations, a full plenary guardianship.
You keep saying we. Who are the other people?
We. I'm talking about we, the probate
We, the
judges.
probate
But yeah,
judges.
but in our court, it's me.
Yes,
It is
okay.
me. So these are the decisions that each probate judge makes in his own court. And we have a probate court assembly where we get together. We have a lot of seminars that we attend together. We share opinions, decisions with each other. So, yeah, it gives me a little comfort to say we, but yes, it is.
Yes, you're the man
It's a
here.
one-person job.
Yeah.
Yeah.
Now, there's something about conservators. What is that?
Yeah, that conservators or conservators, people pronounce it both ways. Again, this is an appointment process where there's a person in need And the way to address that need is to get them some help. And so a conservator will be appointed for a person who's unable to manage their own affairs. And so I don't want to get too far into the weeds here, but there's two types of conservators, one for the estate and one for the person. A person may need both, a person may need just one or the other. And a conservator, the person, would be appointed where somebody's having trouble and literally unable to manage their own personal affairs. For instance, decision-making about medical procedures or where to live, or educational decisions. And then there is a conservator of an estate would be for someone who has assets and is unable to manage them. And so the difference, it sounds similar to, guardians for intellectually disabled, but if you recall, the guardians for intellectually disabled, these are people who have generally been born with a disability or maybe a progressive disability since they were children. Conservators are appointed generally later in life where someone has just gone through a deteriorative medical process. So, for instance, senile dementia.
Right.
So you'll often hear of conservators being appointed
Very
for
common.
Right, very common for elderly people who
Yeah.
are starting to show signs of senile dementia. That's not the only occasion, but it's a typical example. But other times, someone's in. Could
And
be
who would you appoint?
Yeah, well,
What kind of person?
well, usually it's hopefully a family member.
Okay.
Okay, so we have a husband for a wife for a husband is generally ideal. For older folks, it might be a child, or sometimes two children as co-conservators to help each other out. There are situations where there is not a family member who is available to help, and then we look to outside third persons, and generally it might be an attorney. We have a list at the Probate Court Administrator's Office of attorneys who are willing to step in as attorneys for people without attorneys, but also as conservators sometimes for people.
Now, since
that
the
don't have that.
the elderly people, may not be able to defend themselves, how do you know these people are doing the job they're supposed to do?
Yeah, well, it's a good question. Well, first of all, it's you don't come in and just ask for it and it's done.
Yeah.
We have a hearing process, and it's a recorded hearing process, and it's a full-blown factual hearing on whether this person needs a conservator. It has to be backed up by medical opinion, and it has to be backed up by evidence that this medical condition or psychiatric condition has manifested itself in such a way that this person cannot handle their own affairs by themselves. And so we take testimony, take examples. How is this affecting this person? I'll talk to the person themselves. We'll see if they're objecting to the appointment of a conservator, if they even understand what process is occurring.
Any system of back checking, though, let's say 1 or 2 years down the line.
Oh, right. There's a regular reporting requirement.
And this is
Okay.
done by a social worker, perhaps, or
This is done by the conservator.
the conservator?
They have to file reports with us,
Okay.
and we review them, and we bring them in for hearings when necessary. Also, these conservatorships are, we try to tailor them to the particular person. Again, so it's not an all or nothing. Oh, you're under a conservatorship. Sorry, you have no independence at all anymore. No, what we try to do is we try to do it in the least restrictive way possible. So that if somebody, again, just needs help with their banking, all right, then that's what we're going to appoint, a conservator to help with their banking. We'll define the duties of that conservator very narrowly. And then, as you might imagine, sometimes things change.
Yes.
And you might have a conservatorship that now it needs to be expanded a bit as they get older. So we do that. We follow them, and that is a function of the court. And as I said before, these people are agents of the court. Okay, so I take responsibility for the fact that that conservator is out managing the affairs of that person, but ultimately, I have to make sure they're doing a good job. And so we do that.
And are there, other than this, now, is there any more about that that I've missed? Something else?
Well, so that's pretty much it. What I'll say this. I think we're fortunate. You know, I did a lot of this in my private practice before I became a judge, and I was appointed for several veterans who had nobody, no family, and I became their conservator. And what I'm finding here in our district, Guilford and Madison, is that we're very fortunate in the fact that we have a lot of families, the nuclear family, but we also have extended families, like people stay in touch with their grandparents or their cousins, and you know, not always, but it just seems like we have a higher number of those cases, and the reason that's significant is when somebody does need a child does need a guardian, or grandma needs a conservator. A lot of times it's a family member who's willing to step in, and that's comforting to me. That's comforting to me.
And are there other probate court functions that we haven't talked about?
Yeah, so we have some quite a few other things that we do. We issue orders about the disposal of the remains of a person, for instance. If there's a funeral home, they don't know what to do with it, we'll issue an order. We do name changes. We do psychiatric commitments. Now, we don't have a psychiatric hospital in our district, but in those districts that do, a high volume of their work is psychiatric commitments. In Middletown, in fact, they have several hospitals, and I know the judge up there does quite a bit of that work. We do commitments for alcohol and drug dependent people. And there's a bunch of more obscure things. We even have a role if there was a public health crisis and there was a quarantine. The probate courts are the appeals process. If somebody was to be quarantined for a health risk and they challenged that, we would hear that case. So
I remember seeing a lot of that when I was young. You don't see it much anymore.
You don't see it much anymore. In fact, there's a separate statute for tuberculosis, which used to be quite a significant problem, but not so much anymore. But it's still on the books.
And so if someone dies and no one claims them, that's your job too, to take care of what happens to them, and that's what I'm hearing.
Well, we would be asked to issue, I haven't run into that yet, but we'd be asked to issue an order to do something with the remains. Presumably somebody would take them on.
Probably less out here in Guilford and Madison than in like New York City, where you might run into that.
Yeah, true. And usually, if there's any assets at all, usually there's somebody who's aware and wants to get that transition going. Will step up, and once you step up, you're in for a penny, in for a pound.
Yeah, sure. Are there problems that Guilford and Madison have in common with other districts? I think we're talking about that already.
Yeah, we're different in the sense that because we're out here on the shoreline, it's maybe a little quieter. We don't get the volume of really difficult cases, but we have them, Dennis. We definitely have them, and it's maybe a little bit more undercover out here, not as obvious. But there's mental illness, there's domestic violence, and that's something, and drug addiction, and they cause big problems across the board for children in the district and for older people as well. So we share that with really every district in the state, and as I said, we're fortunate that often we have family that steps in and helps.
Now, are there recent changes in the probate court?
Yeah, there are. I mean, I would say the consolidation changed things quite a bit. Okay, I mean, I remember even as a private attorney going to different probate courts, sometimes you'd just be sitting across a desk from the probate judge. And I remember thinking, this is a judge, this is a court. It kind of was. And then other courts were much more formal. And I think there's more of a consistency now because all of the courts are larger than they used to be. The smaller ones are larger than they used to be. There's a little more attention to formality, probably a little closer attention to the rules of evidence. I think that we've done a good job statewide of putting a good set of forms together for the more typical things that keep arising in a probate court, so that there's more consistent application of the law, more consistent procedures in the courts, and I think that's helpful. Conservators, and I'll just mention this as another significant change. Conservators used to be like every other probate court function. It would be heard in the probate court, and then if appealed, it would be de novo. In other words, heard all over again from scratch in Superior Court if somebody chose to take it that way. And one of the changes that was made with respect to conservators is they realized that doesn't really work for, this is an important, significant decision that impacts somebody's independence. You can't just kick the can down the road. So now that there is that one hearing on conservatorship matters, it happens in the probate court, it's on the record, and so it's a lot more formal than it used to be. Certain findings have to be made, and that is the one and only record. So even if it's appealed to a Superior Court, that Superior Court judge is only going to look at our record and hear our transcript, our tape recording of they're not going to hear new evidence. So that's significant. It's a bigger responsibility that the court has now.
And what are the educational requirements to become a probate judge?
Probate judges, another change with consolidation, it was now have to be an attorney. They don't. It used to be not a requirement that you be an attorney. In fact, my predecessor, Joel Helander, who did a fantastic job, very responsible and knew the probate laws very well, was not an attorney. But they changed that, and in 2010, the judges who were sitting, who were not attorneys, were grandfathered in and could continue to serve. But that's the only requirement now, is that you reside in the district and that you be an attorney. Once you're elected, you're required to have 40 hours of training, judge training, judicial training, before you can, before you're sworn in. So I did that, and then there's continuing education as well. So there's
And how do you do that?
yeah, there's seminars. There's
Okay.
seminars that you go
you
to.
mentioned it earlier, yes.
Yeah, and so they require.
Where would you go for a seminar?
Yeah, well, different places in the state. Sometimes at the Probate Court Administrator's Office in West Hartford. Sometimes they'll rent out, a hotel conference room. We've done a bunch at Central.
And who puts these on?
Different, sometimes it's judges, sometimes it's local attorneys, depends on the topic. And so they require that you do 15 hours per year, which is generally, I would say, probably 5 seminars. And what I like about it is they give them all year, and they're free to the probate judges. So I go to as many as I can. I did probably 32, 35 hours last year, just because it was available and I was available, and I thought, let me, the more I can learn, the better.
Yeah. Now, probate judge is the only judge I know of in this area that's elected.
Yeah.
Why are you elected rather than appointed?
That's just historical. It's in our state constitution. Probate judges shall be elected from the district in which they serve. So you're right. It's the only, and as far as I can remember, historically, it's the only judge position that's ever been elected, and the rest are appointed.
It's different than the other political jobs, isn't it?
Yeah, I tried to, when I was running for this office, I tried to make that point with people that, and I think people understand it, most people. While it's an elected position and we appear on these party lines, it's really a completely non-political type of job. We don't set policy, we don't take positions on political issues. All we do, again, I'm saying we, I mean me, my responsibility is to follow the probate laws, and when there's a conflict that needs to be resolved, to listen carefully and resolve it. And with that, to make sure that anybody who's an interested party has had notice that their interests may be affected, and then an opportunity to be heard. That's due process. That's basic due process. So that's our job. But it's non-political, despite the fact that we are selected by elections.
And how often are you elected?
Every 4 years. Yeah.
So you get a full 4-year term. That's
Right,
good.
right.
Yeah, so
Which is good. I think it's helpful. It takes a little bit out of the, political pressure, if you want to call it, out of the situation. People realize you're at least in for 4 years, and hope to be in more than that, obviously. It's an unusual situation.
Now, you told me earlier that being a probate judge was sort of part-time, that you have other things that you get.
Yeah, the probate position is what I would call a very substantial part-time job. All right, so it doesn't take 40 hours a week, at least in our district. There's different size courts. But when you take your oath, obviously, what you're swearing to is that takes precedence. This is your primary job, and it is for me. And then most of us, I think all of us, do run our private practice in addition to, and it's limited. So for mine, I won't take a case that might end me up on trial for 2 weeks. I don't think that would be proper. But I can still do smaller civil litigation matters and workers' comp and closings and things like that.
Do you do probate-related things?
I do probate as well, although not in my district. Obviously can't do that. And the other thing, other restriction, and this is all set out, we have a code of judicial conduct for probate judges as well. And one of the other things that we do not do is take on any contested probate matters in any district. And I think the thought process there is they don't want one probate judge going in and having his case heard by another probate court judge. It wouldn't be appropriate.
Because you probably all know each other. You all go to the same seminars.
We go to the same seminars, and you know what? It's of assistance to us to know each other, because we can kind of share some of the decisions we've made. When I have a tough one, I don't defer it to anyone, but I'll say, gee, have you run into a case where this type of challenge to a will has happened? I did have a case like that. Let me send you the decision, and it might give me a running start on the research for that, as an example.
And why did you become a probate judge? I mean, not everybody seeks the position.
Yeah, well, for me, I've practiced, I'm getting old. I've been practicing law for 34 years, and in a general practice, but always did probate as part of my practice. So, and as I mentioned before, I would take appointments out of the probate courts for different roles. So I got very familiar with it. And I came to recognize that, the decedent's estate very interesting, and you want to follow the law, but I also came to understand that the probate courts are an important part of the safety net that we have for people who have some difficulties in life. And at this stage in my life, I felt like that was a responsibility that would be very rewarding to undertake. And I've enjoyed that.
So you kind of grew into the position and grew to like it and feel that, to understand the importance of it.
Yes, yeah, that's a good way of putting it. I do think it's important. And I'm hoping, one of the things we try to do, and I try to do, is a little public outreach, informing people what the courts do. And that's one of the reasons I was so happy that you
It's our very job here.
asked me to be on tonight, so I appreciate that. I should also say that my predecessor, Joel Helander, was very helpful in the transition, and I thought a very good example of how to treat people, especially in that kind of social services component of what we do.
Is there anything you'd like to add?
No, that's it. I did want to thank you, and if anybody has any questions or would like to stop by the court, now you know where we are, right by the Madison Green. Stop by. We have clerks there 8 to 4 o'clock every single day. They're very nice, very helpful, and I'd always be willing to answer any questions that people have as well, as long as it's not a pending case.
Okay. Okay. And so that's all for this evening, and I hope that this discussion is beneficial to you and that you are able to use it in your life. So thank you very much, and good night.